I'd be happy to introduce my friend Michael Crowley. And Michael is an attorney with Conlin, McKinney, and Philbrick in Ann Arbor. And we share mutual clients, actually. So I've worked with Michael. He's a good resource. And I know that he takes great care of his clients. So he's going to give us a talk about estate planning at a high level, and would like to make this interactive so that we can all get questions answered.
Yeah, absolutely.
So, thank you, Michael.
Okay, sure thing. Yeah, of course. So yeah, as Pat mentioned, I'm a partner with Conlin, McKinney, and Philbrick downtown Ann Arbor. I've been practicing estate planning for about 10 years. Grew up in Ann Arbor, went to Abbott and Forsyth and Pioneer, so have ties to the community. So yeah, this is just generally discussing estate planning kind of at a high level. We'll talk a little bit about planned giving and ways to give towards the end. But I really encourage questions as you have them. Feel free to let me know and would be happy to answer them. So without further ado, we'll hop in. So basically, estate planning is what I have here. It's a plan for managing and settling your affairs in the event you're incapacitated or if you pass away. So my approach is when I'm working with clients or just general information is we definitely plan for death, and that's what a lot of people think of first when they think of estate planning. But you also plan for disability, because if you have nothing in place as it relates to your disability planning, that's when you have the probate court involvement. And that's what I think a lot of people, when they hear about some of the challenges with the probate court, that's kind of what they're getting to. So it's important to plan for both of those components. And I actually think the disability planning side can often be a little bit more valuable. So a comprehensive plan will include powers of attorney for medical and financial decisions. It will include a will. In almost every case, it will include a will, but then sometimes a trust will be a component of people's plans depending on their circumstances. And then making sure beneficiary designations are updated on respective accounts. So retirement accounts, life insurance, even things as simple as bank accounts, it's important to make sure beneficiary designations line up with your intent. And we'll talk about why that's important in a minute here. So we were talking about it before we started here, but without an estate plan or direction as to where your assets are supposed to pass, it's not 100% guaranteed that is going to either pass to a surviving spouse or pass to children. The way that the law works, and if you have no plan, in some cases it'll be the first $150,000 to a spouse, and then the balance is split between children and a spouse. It's just not always the way that people intend. So it is important, kind of at a very basic level, just to have something written down outlining what your wishes might be. So I'll start just first by talking about planning for disability. So this looks different, depending on your circumstances and for everybody, but some things to consider is, who would pay bills in the event that you can't manage things on your own? Who would direct the management of your investments? Taking withdrawals from a retirement account, just basic things that we sometimes take for granted. It's important to have a designation for who can make those decisions for you. And then we kind of talk a little bit about medical care. Again, if you have nothing in place, there's a kind of a misconception that a spouse automatically has the ability to make decisions for you. If you can't, that's not actually the way that the law works. You have to have somebody designated. A spouse would have priority, but you still have to go through the probate court to have them appointed, and it's time and expense that you'd otherwise avoid if you just have that document. So,
can you put that time and expense into some more tangible?
Yeah, sure.
Is it weeks, months?
It kind of depends. So, you're dealing with the probate court, so you're on their schedule to some extent. So if I'll just take myself as an example, if I didn't have a medical power of attorney and I was incapacitated, if my wife had to make a decision for me, if it was on an emergent basis, she could probably get a hearing within a week. But it will often depend on the court's caseload and their availability to issue orders in that way. And then expense, anywhere from $1,000 to $3,000 or $4,000, just depending on the circumstance. If it's all clean and easy, it can be on the cheaper side of that. But if you have, a spouse from a second marriage and a kid who they both want to make the decision for that parent, you end up in that area where you'd otherwise rather avoid.
On general accounts,
Mm-hmm.
maybe anticipating where you're going,
Mm-hmm.
but like your checking and saving, your bank account,
Mm-hmm.
and your individual investment account,
Mm-hmm.
if your joint name is on,
Yeah.
would I have to put my son's name on also to get him access to it?
You would. That's a good question, and I'll get. There's a couple layers to that question.
Yeah.
If it's a joint account, the short answer is if it's a joint account, the joint account holder can still make any decision. So if it's a joint account with my wife and I,
Right.
if I'm incapacitated, it's still her account.
Right.
In the same way, if I die, it's still her account. We don't have to deal with probate or anything else. So joint account ownership is definitely a way around that. But not having the disability documents in place as it relates to finance is, if you have nobody in place, that's when you start looking, like for individual accounts, that's when you start looking to the
I
court.
thought I remembered my banker saying to me once that if I wanted my son to have access to my safe deposit box,
Mhm.
that he'd have to be named.
Yes. Yep. That's true.
I'd have to go to the bank and get his name on it.
Yep.
To get access to those.
Safe deposit boxes are one of those funny assets, and Pat can probably speak to this. Where they have their own set of rules. There's documentation within the Michigan Estate and Trust Code that talks about that. So they're a little bit of a misnomer, or they're unique in that way. But yeah, that is an important thing to have.
For saving and checking account, Sam?
Well,
It's a joint account now.
if it's a joint account, and you could name Zach as a power of attorney, and I think Michael will get to this, but
Mhm.
it's probably cleaner if you're all on the account.
But if he has general power of attorney, would that count for investment accounts and bank accounts?
If you were incapacitated, unable, your spouse was incapacitated, then he would have access and rights over that account. But I'll
Yeah, no,
Michael on that.
Okay.
That's
I
right.
think I tried most of them, but not all of them.
Yeah. And there's a distinction, and I'll probably get to it. There's a distinction between naming somebody as an account owner with you and an authorized signer on the account. And I'll talk about, I don't even think I have it in the slide, but we should talk about it because people have questions about it often. I don't necessarily like making Zach, for example, a joint owner, because then it's his account also. And let's say you have other kids. If you were to both pass away, it would all go to him. And we would trust that he'd do it in the right way if he had siblings, but it's you just deal with, there's gift tax issue. There's just a lot that goes into that decision. Right. So I don't always love joint ownership, and we can talk about why.
Michael, just a quick review. If my wife and I have wills, we have medical directives, powers of attorney,
Mm-hmm.
all kinds of stuff. Do we, if there's some untoward thing has happened, do we still need to go to probate court?
No. Yep. Then that's exactly right. If you have the correct documents in place, that's designed to help you avoid having to go to court to have decisions made. This is all only in the event that you have nothing. If you have the powers of attorney and everything in place, whoever you've named just steps in, makes the decisions, and everything runs smoothly. So that's why it's important to have even a very basic plan in place. It's important to have that outlined. And again, I don't have it in the slides, but I can talk about what a very basic plan can even look like too. So, of course. Okay, here we go. We're getting there. Again, if you don't have a medical power of attorney, then you would have to have a guardian appointed for you. That's the terminology there. If you don't have somebody named as a financial power of attorney, then you would have a conservator appointed for you by the probate court. So those are those roles that those people would serve in. And then I outlined some of what the disability documents are. So they're called various things, sometimes an advance directive, a living will, and designation of patient advocate. There's a number of terms for the medical decision making, but that would be one of the documents where you outline who can make decisions for you, and sometimes what those decisions would be in the event that you're incapacitated. It of course goes to end of life considerations as well. Our document at least will say if I can't recover from something, then you can let me go. You don't have to keep me on artificial support. So that's important also, because if you don't have that there, then you're again in front of the judge, taking a position as to why we can terminate support, because the health system just can't make that decision on their own. The durable power of attorney for finances, and Pat made a point there. If let's say the person who creates the document, let's say it's me, for example, if I have a power of attorney, the way that my power of attorney document works, it's effective when it's signed. So they don't need to prove that I'm incapacitated for that document to be effective. My wife, let's say she's my agent, regardless of my capacity, can make decisions for me. And that's distinct from when it's called a springing power of attorney, when it only springs into action when you're incapacitated. This is maybe more detailed than you guys want, but that's a difficult document to use, because if I'm incapacitated on, let's say, October 1st, and my wife tries to use the document on November 1st, Bank of Ann Arbor, not that they do this, but Bank of Ann Arbor might say, hey, look, yep, we understand that he was incapacitated last month, but we need something new now showing that he's still incapacitated for you to be able to use this, because there's liability to them for letting an agent, act there. So ours start when they're executed, and it lets the person just immediately act for them. So then the last two documents that we'll typically include in an estate plan is the authorization to release medical information. So just under the HIPAA laws, kids can't access parents' medical information or talk to doctors without authorization. So we will list who you would want to be able to receive information. And then relatively new, the last 5 years or so, there's a law that talks about how digital assets can be managed. And so that's a newer document. If you haven't talked to your attorney recently, it might be worth just checking on, because if you have nothing in place, your agent under your trust or will, they don't have legal access or authority to get into your email and passwords and phone and those type of things. So it's a nice thing to just include in your plan, just to make sure that whoever you've named can legally access that information. Thoughts or questions on the disability piece of this? All right, we'll keep moving.
Do you know the stats? People always think in terms of death, disability is something like 100 times more likely to happen, right?
I hear
that's one of the reasons to focus on it.
Yes.
But do you know the specific?
I don't know the statistics. The people that I work with that try to sell me life or disability insurance definitely quoted at me quite a bit. It seems a lot more likely. But
intuitively, it seems a lot more likely. Those numbers with those lights.
Yeah, they throw them out. Yeah.
At you, like, wow.
Yeah, exactly.
So
yeah, no,
it
is, and it's good. I guess every stage of life, it's important to have those documents in place, because it can happen to anybody at any time. But it's just such an easy thing to do. It's 4 documents. It's not all that expensive, and it really avoids a lot of head and heartache if you don't have that in place. So it sounds like most of you guys have that, but just for information and for whoever might be tuning in, it's good to have. So the disability planning, we just touched on that. The other kind of piece of estate planning is just planning for our own death, and it'll happen to everybody, unfortunately. But there are kind of 4 main ways that property will pass, and it's important to kind of understand these distinctions. And I'm sorry, sir, what was your name? Chuck. Chuck had made a good point here. So the 4 ways that property will pass will be joint ownership, transfer via beneficiary designation, through the probate process, or through a trust. And we'll talk about what these look like. But when I meet with clients that are settling or administering a loved one's estate, this is something that we'll cover, just so they can understand the distinction as to how property actually will pass. So again, the first, joint ownership, I just give a couple examples here. So and I'll just speak to myself. So my wife and I own our home together. If I pass away, then the home is just hers. We don't have to go through the probate court. It has nothing to do with our trust. It just becomes her home. Same thing with the brokerage account. If we own a brokerage account jointly, the survivor just inherits it. And then Chuck, you had referenced the checking and savings account, same thing. If my wife's on my checking or on our checking account and I die, or vice versa, the survivor just takes it. And again, to your point, if you added a kid to the checking account and both parents pass away, that just becomes the child's account. So that was I think a little bit of an older style of planning, is just name kids on all of your stuff. Name kids on your checking account, your brokerage account, your home, all of that. And the reason I kind of avoid or advise people to stay away from that style of planning is that there's a couple different reasons. One is, if a kid is joint on a checking account, their creditors can theoretically get to that account of the parent. So it depends on your circumstances, but there is some level of risk to having joint ownership there. Other assets that have the ability to appreciate, like real estate or stock accounts, at death you get what's called a step up in cost basis. So, and we can go into this as much or little as we want, but if I bought my house for $300,000 and when I die it's worth $500,000, if I sold it on the day before I died, I'd pay the $200,000 in the gain there. If I die still owning it, the government lets you kind of reset the starting value for that, and then my kids pay no tax. So if you put a child on a brokerage account or a home, they lose that step up in cost basis. They get what's called carryover basis, and then when they go to sell the house, yeah, they've avoided probate, but then they're going to have to pay that $200,000 in capital gain tax. So that's, a lot of people will come in with plans that they did 20 years ago, thinking everything's fine. We've got our kid on our house and our bank account. We're going to avoid probate. That's our goal. And there's a lot of unintended consequences there that will sometimes advise them to stay away from. So beneficiary designations is the second way that property will pass. Again, this is a way to avoid probate. If you have a checking account or a brokerage account and you're joint on it with a spouse, again, at the first death, it's joint, so nothing happens. At the second death, your beneficiaries will be whoever you've listed on that account. And that is a contract that you have with the financial institution. So if you're with Vanguard, Schwab, Fidelity, Bank of Ann Arbor, if you have beneficiaries listed, whoever the custodian of that account is required to transfer the funds to those beneficiaries at death. So it avoids probate, it avoids the trust, it just directs where that property is going to go. So that's another thing that's important as you look at your own estate plans or think about this. If I have an old beneficiary designation, which I think I'm okay on, but before I had kids and I was married, I might have listed my parents on my beneficiary designation. And now that I have a wife and kids, if I haven't updated that, the bank is required to pay that money to whoever the beneficiary is. And again, it just makes things complicated in a way that you could, otherwise avoid. Yes, sir.
Brokerage account, does it have to be sold to be sent to the 3 kids in?
No, so that's a good question. There would be 2 options. They can take the distribution in cash, where it would be sold and given to them. They can also take it in kind, where the securities are just split 3 ways. It's sometimes difficult to transfer fractional shares, so they'll sell those little pieces out there. But otherwise, yeah, they can take it in the same character that it is in. I see it in the case of when someone passes. I typically see them distribute it in cash because you get that cost basis step up. So there's no cost for the kids to sell the stock when they inherit it. It lets them diversify it, or they can keep it as it is, and there's no issue there. That's a great question, though. So again, beneficiary designation just is going to control where that property is going to go. And this TOD and POD designation is transfer on death is one term of art, and then the other is pay on death. They mean the same things, but different institutions will use that term differently. So if you were to check on your beneficiary designations, you could just ask that if they have a transfer on death or pay on death on the account. Okay. The third way that property can transfer is through the probate process. So if I have a bank account, if I have any asset that's in my name solely when I die, that goes through probate. If it's joint ownership or with the beneficiary designation, we're avoiding probate entirely because those operate in a different way. But if I pass away just owning, for example, my house or my checking account in my sole name, that's an asset that's going to go through probate. Probate's the legal process of distributing your property to your beneficiaries or your heirs. Again, I state it here, but if you don't have a will, those assets are subject to probate. And then Chuck and I were talking about it. It's not necessarily the case that would go directly to your spouse or to your kids. There's laws as to how what's called intestate succession. If you don't have a will or have something written down that directs where your property is going to go, the law will say, the law has, what's going to happen there. So it will just depend on your circumstances. So I list a couple of disadvantages. There is sometimes a delay in working through the probate process. There are some costs to do it, and then there is a level of lack of privacy where any filing with the probate court is public record, your will is public record, the amount that's passing through probate is public record. So some people have some concerns about privacy. My philosophy is I'm not worried about probate. I think a lot of financial advisors and estate planning attorneys and life insurance, there's this whole industry of people that try to scare people about probate, that you should avoid it at all costs. It's incredibly expensive. It takes years to get through. That's not really the case. In Washtenaw County, we have a process called informal probate. You're never in front of a judge. It's our court is great. It takes typically a week to get somebody appointed, maybe 2 weeks to get somebody appointed as your executor or your personal representative. The cost to go through it is a fraction of 1%. So if you have a $500,000 house going through probate, you're paying under $1,000 in court fees. It's not a horrible process. There are a lot of people that come through my office that will say, we need a trust, and we talk about what their needs are, and we end up going with a plan that just lets their house and their bank account go through probate because they, just whatever their goals are. But it's not a bad result to have things go through probate. I will say if you have a trust already, or you can give your property by a beneficiary designation or joint ownership, that's preferable. I mean, why incur the time and expense if you can otherwise avoid it? But there are situations where probate's a fine outcome for people. So I list some disadvantages, but I don't really, they're not that bad. It's not a horrible process. And then the final way the property can pass is by or through a trust. So a trust this is a little technical, but it's a relationship established when one person is considered a grantor, transfers property to a second party for the benefit of a third. So it's more complicated than it needs to be. I can create a trust by just drafting a trust. I say it exists, and eventually it will be funded with some of my assets at my death. You create it. In most cases, we create revocable living trusts. There are times for an irrevocable trust to be created, but in 90% of cases, that's not necessary. So it's revocable. I make changes to it as I need to. My wife and I have one for our minor children for reasons we'll get into here. But I know that I'm going to change it over the next 5, 10, 15 years because my life is going to change. My kids will change. We'll have a better understanding of how they're going to be and how they can manage property and whatever their goals and risks are and everything. So it's a very flexible document. It does allow us to avoid probate because if assets are owned in a trust or payable to a trust at my death, through beneficiary designations or otherwise, we avoid probate on that. And it gets directly to whoever my beneficiaries are in my trust. It does keep it clean. Essentially, upon my death or on my incapacity, my trustee immediately takes over my accounts, those assets, and they can just start acting. They can sell my house the day I die if they feel like it. They can sell my stock. They can do whatever they need to do. So it's a great tool depending on your situation, what your needs are, but it's not necessarily the end all be all of plans. I mentioned here the trust becomes irrevocable upon the grantor's death. So at that point, if I were to pass away, my wife and I die, then no changes can really be made to it. And then there's these last two bullets here. They don't typically come into play unless you have two, like a husband and wife each have their own trust. So we can talk about that if anyone's got questions, but those are based more on estate tax planning. And right now the exemption for people to pay estate tax is $12 million. So that's per taxpayer. So most people are not overly concerned about avoiding that because it's such a high number right now. Okay. So advantages are going to be you avoid probate. There is some level of disability planning built into the trust. So if I'm incapacitated, my trustee can just step in and manage things for me. So that is helpful. It kind of operates in the same way a power of attorney will operate. There's some estate tax benefits there, again, for the people that are in that $12 to $20 million range. There's some benefit there. And the biggest thing I think for most people is it allows you to avoid probate and control where that property goes. So I'm a good example for why trust can be helpful. I have 2 young kids. I don't want them to inherit everything when they turn 18. I wouldn't have done well inheriting whatever I have now when I'm 18. I don't really want that for my kids. So a trust allows you to say, hold it for them and distribute it at certain ages or certain milestones. You can totally control what happens to that property. So if you have, minor children or kids that might have, some credit or substance abuse issues, might have disabilities, whatever, a trust is a good tool for managing those situations. And then privacy is kind of an afterthought to some extent, but it's never part of the public record. Your assets are not, subject to the probate court. There's no supervision. It's very clean and easy to manage this. Okay. This is plan giving. This is kind of, it's a little bit of a different, section of this type of planning. Anybody have questions on wills, trusts, any of that before I shift gears a little bit? Or does it all, I know some of you have plans already, so this is maybe just a refresher, but.
Well, I think it's the documents you're talking about are not just for assets. You focus on assets, but it's also for childcare.
Yes.
Just spelling things out.
Yep. Yep.
Who cares for your kids?
Exactly. Yeah.
When things happen in the timeline.
Right.
Etc.
Yep.
Is all part of this.
Yep. And this is very, very high level. You can get into as much nitty gritty as you need to within that type of plan. So you can say certain dollar amounts a month. The way that I typically plan how my own trust works is essentially I give complete discretion to the trustee is the person responsible for managing things. They have complete discretion to spend for my kids. I don't care. I'm going to be gone. I trust that they're going to make good decisions. I emphasize education to some extent, but if my kid wants to go play travel soccer, my trustee spends that for them. If they want to go out of state to school, the trustee pays for that. It's very broad. And then I say the trustee is going to give them money at, let's say, 30 and 35. They get the balance of their share distributed. But that's just my situation. It's totally dependent on what the client's needs are.
But the trust document allows you to write your own stories. So
Exactly.
You can
Yep.
make it as detailed or as general as
Exactly.
That's the point.
Yep. Yep. And that's a great point. Whereas a will or beneficiary designation, the beneficiary just gets everything at that time. There's no strings you can put on it. They're just going to get that money. So for a lot of families, that works great. The kids are old enough, responsible enough. They're not going to make bad decisions. The parent just trusts that they'll make the right decisions with those funds. The trust does, though, give you a little bit more control over how that's managed. So yeah, good points.
Michael?
Yes.
Just a quick question. Everybody's situation is different, but it would be fairly normal, in Diane, in my case at least, for each of us to be named as trustee under those individual trusts.
Yes.
But then the idea of a successor trustee. So if we both are gone, somebody else needs to step into that role.
Correct.
Okay.
Yep.
So that's something that your trust document would typically address.
Yep. The trust document, the will, all of the disability documents, we always will name a primary who will make those decisions for you. Then we'll name a contingent so like if it's not my wife and I, it might be my brother or my mom or dad. And then we will sometimes have a mechanism for appointing a successor if everyone down the line could not act. So there's a lot that's kind of baked into them that will adjust for change in circumstance. Yes, sir.
The trust transfers from a husband to a wife on the decease of one. Then it's okay to have it all divided upon the death of the second spouse. To have it divided among your 3 kids.
Yes. Yep. So most trusts that I will draft for people that do not have over $20 million, we call them joint trusts. So it's a trust between a husband and wife. That's how my trust is set up. My wife and I are joint owners on the trust. So if I die, it's still her trust. She can still amend it. She can revoke it. She can change the terms. It's still all her money. When she passes, that's when it's irrevocable. When I will draft documents for our 2 trusts, one for a husband and one for a wife, for example, we typically do that only if there are estate tax considerations or if maybe it's a second marriage where they come together with kids from prior marriages and they have goals where they want to help their wife or their husband in the event of one of their deaths, but also make sure that their kids are protected so that spouse doesn't either remarry or cut the kids out, or there are ways to plan with second marriages and kind of blended families that we will incorporate 2 trusts for. Good questions though. All right, so this is just a little bit on plan giving. I know that's part of the Legacy Partners program to some extent. So I'll just talk again high level about some different opportunities and ways to leave bequests. So one is just gifting with cash. we all know what that looks like right now. You can write a check to your favorite charity, the church, anybody that you'd like. We have the deduction of your adjusted gross income. That's straightforward and I think pretty self-explanatory. Gifting appreciated securities, you've probably all heard at some point where you can gift stock. So if my Ford stock has appreciated significantly over the period of my life, where if I were to sell it, I'm going to pay a lot in capital gain tax, I can gift that stock to a charity. The charity is going to pay no tax on it. They're going to get all of that benefit, that growth benefit, and then you're not going to pay any capital gain tax, and then you also get the charitable deduction. So a lot of people like to gift with appreciated stock. It's a good tool to be aware of. I'm going to skip the will and trust for just a second. Gifting with retirement accounts. I meant to add a slide or add a reference here. So there's two benefits here. So a lot of people just think I'm going to leave money through my will or my trust to the church or to my favorite charity, and that's a fine way to give. The church appreciates that. The charities appreciate it. They're gonna get that benefit. I will often in meetings with clients tell them to consider leaving the church or their charity as a direct beneficiary on their retirement account. If you think about it, the retirement accounts are tax deferred. We have never paid tax on the money that goes into those. The charities are tax exempt. So if you leave money directly to the charity from a retirement account, we avoid paying the government anything at any point. So they get the most benefit there. If you leave it through your will or trust, say I leave $50,000 to my favorite charity, that you've already paid tax on that money. You've paid income tax on it, you've paid capital gain tax on it. Over the course of your life, you've paid that tax, and then the church is going to get it tax-free, and that's great, but you're leaving the most to them if you leave it through a retirement account directly. So a lot of people will on their Vanguard or Fidelity account, TACREF account, say $50,000 to each of these charities, and the balance will be split between my kids. And that way, the church or whatever their charity is getting the maximum benefit tax-free that you could possibly give. And so I will oftentimes cut that charity out of my trust entirely because we're planning for them in a different way through that beneficiary designation. So I think that's a great tool that a lot of people are not as aware of as I think they could be. So then, of course, a will and a trust. I mean, it's any charitable giving is great. Any legacy planning is great. You would just name, whatever charity you want within your will or in your trust, and then the trustee or your executor will make sure that those funds are distributed. It's an incredible gift. Sometimes there are more tax advantage ways to do that. Keeping on the retirement account piece just for a second, there's another type of planning that I did not mention is called a qualified charitable distribution. For those of us in the room that are forced to take required minimum distributions from our IRAs or retirement accounts, you can designate that the charity receive all or a portion of that RMD. Normally it would be income that you would pay income tax on that distribution to you from the RMD, but you avoid that if you give that to charity. So again, you don't pay any income tax on it. The charity pays no income tax. It's a great way to give while you're alive, to take the deduction, get maximum dollars to charity. It's a nice tool that I think, rather than writing a check for $50, you work with your IRA custodian and you leave it directly, monthly or annually through your retirement account.
The only slight thing about that is they only pay by check. They don't do electronic.
Yeah, they don't make it as easy as they could, I think, but I'd always rather avoid paying the IRS, even if it's. Yeah.
And it did say here, for instance, there is a place on that QCD where they can put a memo as to if you want to give it to a specific fund. Yep. Within a charity.
Oh, that's nice. Good.
You can tell the administrator that,
Good.
and they can put that on the check as it's sent.
Good.
You can do that itself too.
Or the church, or you can tell the church what's coming in. I said, and in case it comes without, be warned.
Right.
Good. Then I'll tell you
Yep.
what fund, so you double check.
Yep.
Double check that.
Yeah. Yeah. It could be easier. It could be a little more streamlined, but it's a good tool. I'm glad you guys are both aware of it. It sounds like you use that, so that's nice. And then I just have a little slide here on donor advised funds. So essentially a charitable investment account that you set up through, Fidelity has is well known in that space. Schwab is well known in that space. Does Bank of Ann Arbor have donor advised funds? I don't. I'm not aware of that either. But it's a charitable account that you set up. You donate funds to it. You take the charitable deduction in that year, and then you can direct how and when those funds are distributed to qualified charities. So it's a nice tool to have if anybody was curious about those. So. And then there are different types of trusts that you can set up that are charitable trusts, and there's charitable foundations and all these other tools, but it's a little probably beyond the scope of what we're here to do today. So there's a lot there. There's a lot of really great ways to give that are more tax advantaged than just cash or from a will or trust. So, but that's I think what I have. So open to questions. This can be super informal. If you guys have things, feel free to shout them out, and if not.
Michael, on appreciated stock gifts, when I give that to a charity, am I getting the benefit of the appreciated donation, or is it my cost basis?
The appreciated donation. Yeah, it's whatever's in your account right now. If that forward stock's worth $15,000, but you paid $1,000 for it. Yeah, they're getting that full $15,000, and we're avoiding the capital gain on all of that.
And then on my end for the charitable donation, that's what I'm showing as well.
Yes.
15.
Yes, exactly. Yep.
Apart from the maybe obvious conflicts of interest in the various roles that a person could take, there's no legal reason why an executor or a trustee couldn't also be a beneficiary.
Correct. Yep. There's no when they step into the role as a trustee or a power of attorney, they are required to act as a fiduciary. So to put the interests of the grantor or the beneficiaries first. If they breach that duty, then they're liable for the damages there. So yeah, there's no issue with a child serving as a power of attorney or as a trustee. They just need to be aware, and I often will tell them, here are your responsibilities. You're required to account to people. You're required to act prudently as a prudent investor should. There's a fair amount that we'll cover with people if they serve in that role. Yeah. And I think it's great. I think there in a lot of cases kids can serve, or other family members can serve as a trustee, power of attorney, etc. There are also situations where that doesn't make sense, and you want an independent third party fiduciary to do it. And this isn't Pat and I's relationship, but Bank of Ann Arbor does provide those services. They're one of the only shops in town that will serve as a power of attorney, as a trustee. There's a couple other banks that will do it. Old National does it. A couple of the bigger banks, but a lot of the big financial institutions will only take accounts if they're $5 million. That's not Bank of Ann Arbor's situation. So they're a great local resource for people that are kind of in that space. So
trust services.
Yeah, exactly. Yep.
I've had trouble getting the reports on the things that are in my wife's trust, although I'm a trustee
Okay.
of those accounts, Fidelity and Vanguard. I haven't been able to get there and send the report.
Who's the co-trustee with you? Or are you the only trustee?
Well, I'm the only trustee until my kids can take it over. I have my oldest child is if they're available, and then the next one is if they're.
So is it an issue with Fidelity getting you the account information?
Yeah.
That should be something that you could resolve, or you should be able to resolve just directly with them. There should be no reason to not have that.
Okay.
You as a beneficiary are entitled to, put aside the fact that you're a trustee, as a beneficiary, you're entitled to any account information with respect to that trust. So if my parents died and I'm a beneficiary of their trust, I get quarterly accountings, annual accountings detailing what's come in, what's gone out, what the expenditures have been. Beneficiaries have a lot of rights under the mission.
It's a long while to get them to correct it.
That is unfortunately the case sometimes.
Largeness of it.
Yeah. Yes.
So this is more of a counseling question.
Sure.
which I'm sure you would.
That's
end up doing
probably
a lot.
70% of my job.
Right. So we've got 3 fantastic kids, and we would be happy with any of them, you know, being the next person. And I just want that conversation to go, and they might decide among themselves who that is. But do you have any just wisdom or advice about how to support naming that person when you're
when you have that good problem.
Right.
Yeah.
It's a good problem to have.
Yeah.
Want it to be as I don't know, their decision as much as our decision.
I like that approach. If they all get along well enough and no one's going to have hurt feelings, just put it out there that this is a decision that we have to make. Does anyone feel strongly about it one way or the other? A lot of people will do it by proximity. You know, like I have 3 brothers, so me and another brother are both here. So it makes sense to name one of us. I don't always like naming more than one because a lot of families, they have that unfortunate problem where their kids could all do it together. They trust them. But if you have more than one name, they all have to make decisions together. If they're setting their accounts up with Vanguard or whoever else, they all have to be on it. They're signers on it. They've got to all sign the same checks. It just becomes way more work than they want to deal with. So it's partly the approach you're taking is just have that conversation and be open with them. And then I would also communicate to the other 2. What I would do is I'd probably name them in order. So on every document, I'd name them 1, 2, 3, so that they all theoretically could serve if they needed to. Your person you put in the first position could just decline, and the second person could step in. And sometimes their circumstances change. So you could have them 1, 2, and 3, and then it makes the most sense for 3 to serve given the situation that you're in at that time. Then you just do 1 and 2 just decline. The third person steps in and just acts. So that can save some hurt feelings. Sometimes I always try to the extent clients are comfortable, I try to name everybody just in order so everyone sees their name on the documents and no one's left. Because a lot of times people will leave them out. They just say it's me, my wife, and then oldest child. The others are thinking, well, why wasn't I named anywhere? You know, just
like the oldest child doesn't have enough.
Right? Yeah, exactly. I'm the oldest, so me too. So, so I would take their input, let them have the conversation, let them know that they all are entitled to the same information, that they're going to account to each other. That I put them all. I let them all receive statements when, like, if mom and dad both pass away, have the trustee put the other 2 to have access to statements. So there's no. It's not like a black box of information. They all see when dollars are spent. So that's kind of the approach that I take. And then just put them all on it and
that's helpful because that's the open communication.
Yeah.
For all of them is a goal.
Yeah. Yeah. No, it's a work in progress, right? And what I'll tell people too is any time you draft an estate plan or update your plan, look at it every 5 years and see what makes sense still. Because at one point, all 4 of us were in town together. Now 2 of us are here and 2 are split across the country. Like that, if they named one of the brothers who was local, it maybe doesn't make sense to still have them. So look at it every couple years, see that it still makes sense. And then I say just meet with your attorney every 7 to 10 years just to see what changes have kind of come about in the law, you know, whether it's estate taxes or like the digital asset. That quietly rolled out. Not a lot of people know about it. No one would really think it's important. But it can be a really helpful document to have. So there are those little things. Yes.
My 3 kids all live scattered around far away, and they're talking about naming someone to act for them, a local attorney or something. Does that make sense?
So I look at it in 2 ways. So one relates to medical decisions. I think it's nice to have somebody local to help with medical decisions because that can be a more day-to-day process for some people depending on their situation. So I like that idea solely as it relates to medical decisions. Financial, if your kids were happy to name an attorney or somebody independent to do it, I think that's an okay option. It is not difficult to serve as a trustee from far away. You know, you can have a kid in California. They're here maybe once, and then I can work with them remotely on everything else. We hire a local real estate agent. We work with their local bankers. They don't really need to be physically present in town to help in that role. So if they're okay with it and they want someone else to take that responsibility, I think it's good to have that option. But I wouldn't tell a couple to not name a child who doesn't live locally solely because of the proximity to where you are. Hopefully that helps. Things will depend too. You know, if attorneys serve or banks serve, there's always a cost to that. So having that open conversation with the kids and that lawyer to know what to expect as far as cost, because you know if it's going to make them reconsider if they're going to have to pay $10,000, $15,000 in fees a year, they might say, well, I could do that just as well. It's not that inconvenient, and they'd rather do it. So, yeah, but good question.
You sort of alluded to this, but I think a lot of people have the idea that you do a will once and you put it away and
Yeah.
it's done.
Yeah.
How many times, and obvious changes in life events would be having children, marital status change.
Yep.
But how, and you just set up a timeline of 5 to 7 years or whatever.
Yeah.
On average, how much of a working document is it for people? Is it something that gets revised 3 to 4 times?
Yeah, I'd say probably every like 10 years somebody is likely updating their plan. Our firm practice is we send a letter every 7 to say it's been 7. Let's at least have a conversation. But you know, like you said, it's so dependent on their change in circumstance. But yeah, it's usually you set one. In an ideal world, you set one up when your kids are minors. You update it when they're in their 20s or 30s and they are more responsible. Maybe you're naming them to serve as your power of attorney and medical, you know, patient advocate. You update it maybe once more when you start to have grandkids, and then you're probably going to tweak it once more when you're in your retirement or you know, kind of more advanced in age, and you start, you know, maybe your kids don't need that money they don't need it as much. You're setting up 529 plans. You're setting up shares for grandkids. There's all those kind of considerations that will happen. So yeah, it's like 4 to 5 times probably someone will maybe rehaul their plan. Yeah, but then I also have clients that come in every 2 years because they are tweaking one thing or the other. So it's really, it depends on the person, the circumstance, but So.
If there are no more questions, I want to be respectful of Michael's time. It's almost noon.
Okay.
I think so any last questions?
I'll hang around too. I mean, we don't have to video everything. I'll hang around, and I'm happy to chat with people if they have anything else. So yeah, thank you guys. It was a pleasure to be here. Thank you.